car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
And welcome into the attorneys. Thank you so much for joining us this evening. For the next half hour, here's the plan. We've got a panel of experts ready to deal with the topic of conversation that we believe is of interest to you. Always works better if you join the conversation. Ways you can do that at the bottom of the screen, the ways you can communicate with us. Also, the firm of Hollis Wright makes available each and every Sunday evening attorneys standing by live to take your call. So take advantage of that opportunity as well. Leading our conversation, as he often does, Josh Wright.
How are you, my friend?
Sir? I'm good.
Another good week?
I did. How about you?
You know what? Great week. Middle of the summer. Everything's going well.
Clicking along.
Things are on the right track.
That's good.
We're going to be doing a show tonight. Something we've done, but a little different spin on divorce and child custody. And this is not an area that our firm handles, and so we go to the experts. And Brad Latta, who's got his own firm here in town, is an expert in this area. This is what he does. He does some other things too, but this is kind of an area of his practice that he really focuses on. So we're going to be talking about issues of divorce and things that happen during that process and how to get that process initiated and resolved, as well as how to resolve some of the child custody issues that people may be facing if they're going through this. So first of all, Brad, thank you so much for being on.
Thank you for having me.
How'd you get into this area of the law? Because not every lawyer does this, and this is kind of a specialty.
Yeah.
If you don't know what you're doing, you can get yourself in like a lot of trouble.
You can, yeah. It was one of my favorite classes that I took in law school, and I really enjoyed my professor, and I liked the area of law. And when I opened my own firm, there were not a lot of other places hiring, and so I opened my firm, and it was an easy way to start getting cases coming in through the door, because everybody that I knew that I was dealing with at the time had some kind of problem with divorce or custody or child support or something. So it just kind of went from there.
That's great. So tell me this, how do you advise people? Do you advise people if they're thinking about the potential for divorce, or they feel like there's been a breakdown in the marriage, to consult with a lawyer before it gets to the actual stage of divorce to understand what their options are? How do you advise it? Because I know that's a question you've got to get a lot.
It is, and we do free consultations, so it doesn't cost anything to come in and talk. We deal with some people that are in the middle of a divorce, some people that haven't filed yet, that are thinking about it or heard something or talking about it. So all different stages, but we offer a consultation just to come in and kind of see where you are in the case, kind of give you some advice on your options and what you should do at that point.
Well, and I know there are a lot of people in the viewing audience that go through these issues on a yearly, not the same person on a yearly basis, but go through these issues. And if it's not them, it's somebody in their family. I've heard the statistic of roughly 50% of all marriages end in divorce, and I hate that. I'm one of the lucky ones that hasn't had to have that issue, but it is something that people deal with without question.
One of the questions that we have here is about the topic of property and how that's divided up. Yep. I think for a lot of folks, wonder if there's a science or kind of a method to the madness in terms of dividing up property.
There's really not. Alabama is what's called an equitable distribution state, which doesn't necessarily mean equal. It means it's up to the judge to decide unless the parties can resolve it themselves. Everything acquired during the marriage, so from the time you get married until the time of divorce, is considered marital property or joint property, and is subject to division in a divorce. And so we try to encourage the parties to divide their assets and their property as much as they can by agreement. But if they can't, then the judge will hear testimony from both sides and decide what's equitable or what's fair to the judge.
I know we get this question whenever we do divorce-based shows. We get the question related to alimony and whether or not one party is entitled to alimony versus the other. Let's address that now if we can.
Sure.
Is alimony guaranteed each divorce, or is it based on a certain amount of time that somebody's in a marriage? How does that work? Or is it just discretionary?
Yeah, it's discretionary. It's never guaranteed. 10 years of marriage is usually the cutoff that judges kind of go by. Statutorily, it's in the codes. 10 years usually is marriage is less than that. You rarely see alimony awarded. The longer the marriage, the more chance that alimony would be awarded. It's changed over the last 10, 20 years. It's not as common anymore. More people are working, and so it's always up to the judge. It's mainly designed to even out unequal distribution of income of the parties. If one party makes a lot of money and the other party's stayed at home and hasn't worked, then it's designed to balance that out a little bit so both parties can have the same standard of living.
How do you also address the issue of, and we get this question sometimes on the show, if an individual says that they have nothing in dispute with their ex, but they both are in agreement that they want to get divorced, do you ever advise them to do that alone without a lawyer, or do you think it's good to have a lawyer involved to be able to, legalize everything formally?
They almost have to have an attorney. You can do it yourself, but I always encourage the parties to get an attorney. You can each have your own attorney, even if it's uncontested and you settle it, or one attorney can do all the paperwork for both parties. They can only represent one party, but they can do the paperwork and everything for both parties. But courts and judges and the clerk's offices are very specific in the forms. You can't just write it on a piece of paper and turn it in. It's got to be worded a certain way. It's got to be styled a certain way. They like it to be electronically filed, that only attorneys can do, things like that. So I always encourage the parties, even if you settle everything and it's very easy, at least have an attorney, do the paperwork and file it in. It's going to go much easier.
What about child custody? Because that's another thing I believe just folks don't really get how those decisions are made. It used to be, it was almost always seemed to be going with the mom, but that appears to not be the case as much.
Yeah, there's no presumption that either party has the right to custody. It's always what's in the best interest of the children. Like I said, we try to encourage the parties, if they can, to resolve those issues themselves. If they can, it's always better for everybody to come up with your own schedule, your own arrangement. But if you can't, then the judge will decide. And there's, like I said, no presumption, mom or dad, male or female. It's just whatever's in the best interest of the children.
We've had some folks come on before that do this type of family law on custody and child support and those things. And they have really praised the Jefferson County bench and the family court. Do we have that good a bench? Because it sounds to me like we've got a really good bench.
They're very good. Yeah, the judges are good, pretty efficient. The clerk's offices are good. Some other counties that we practice in are not as efficient, but Jefferson County is pretty good about getting people in and out. They don't delay them, for years at a time. They try not to do that. So yeah, the judges are good.
Talk to us about kind of the step process if you get to a lawyer and you make a judgment call to go through a divorce. What has to be filed? What is the process to be able to formalize that divorce?
The first thing that's filed is the complaint for a divorce. If it's going to be a contested divorce that you think the judge might have to resolve, then you file in just the complaint. Okay. It's got to be served on the other party. They have a chance to file an answer or counterclaim. If it's going to be a traditional or contested divorce. If it's a non-contested, uncontested divorce, then usually you file everything in at one time. So it's a package of forms, 10 or 12 different forms, child support forms, everything's got to be filed in, signed by the parties, notarized, and then everything's filed in at one time, pay the filing fee, and then the judge will sign off on it.
When we come back, because I know we're getting ready to go to break, I want to talk more about the child custody side, kind of how that process works, how it is discretionary with the court, and what options you have. For example, if you may not come to the divorce with clean hands because you've made a mistake in the marriage, whether or not that's going to impact your custody. Some important stuff.
Yeah, we'll get into that. We'll step aside right here as we head to break. A couple of reminders. Here's how you can get in touch with us here at the show. Try to make that easy for you to do so. Also, you can find the firm of Hollis Wright on Facebook. If you'll just search the term Hollis Wright, find them there. And on Twitter, it's Hollis_Wright. Hollis_Wright to find the firm there on social media. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into the attorneys. A reminder, this is a show and a topic that elicits a great deal of conversation and need. So attorneys standing by live right now from the firm Hollis Wright, give them a call and see if they can't help you out there. Josh?
So, Brad, when we went to break, I wanted to raise the issue because I think it's important. People that don't necessarily come to the divorce with clean hands, there's been infidelity, there's a drug abuse issue, whatever the issue. You've heard all the stories, I know.
Sure.
How does that impact custody? Because I know custody is discretionary with the court. If somebody comes with unclean hands, are they guaranteed to not have a custodial right, or are the courts willing to work with them? How does that kind of work?
Yeah, from my experience, neither party comes in with perfectly, clean background. There's always issues on both sides usually, and all of that's a factor. It all goes into what's in the best interest of the child. That's the standard the courts will always go back to, is whatever issue it is, how does that affect your ability to take care of the children? Does that affect your ability to raise them emotionally, financially? But it all goes back to what's in the best interest of the child, which is vague. I mean, it's always up to the judge. But usually neither party is perfectly without any kind of issues.
Are there also joint custody circumstances where a child will live different times of the week with one parent and then with the other, for example, if they're the same school system?
Sure. There's joint legal custody, which is very common. Both parties can make parenting decisions, co-parent together. Then there can be joint physical arrangements as well, depending on how close the parties are to each other, if they live relatively near each other, same school zones. Courts usually don't want to move kids around a lot. They want them to have kind of what they consider their home base with their things, and one house instead of being shuffling in the car all the time. But there are situations where it can work. It requires a lot of communication by the parties. They have to agree a lot and generally be on good terms for that to work.
How does this work? Because I know we get this question every time we do a show related to kind of children issues in custody. When does the court start listening to the child's recommendation or request? And I know you hear, one side's trying to poison the child, and I know you get all that, so I'm not even getting into that. But at some point, does the court listen to the child if the child says, look, I want to spend more time with this parent? Okay.
Yeah, and we get that question a lot. Everybody wants to know that. Generally, we don't involve the children as much as we can help that as far as coming to court and testifying and being involved. But if there's sometimes, you can't avoid it, the children can be appointed their own attorney, a guardian ad litem that represents the children. There's no age cutoff, so some 7-year-olds may be more mature than a 12-year-old. It's individual, child by child basis, but usually the older the children are, the more likely the judge will give their opinion weight. They will usually, if they're going to ask the child, I've rarely seen them come out and ask them directly, who do you want to live with? But if they talk to them about, tell me about living with your mom, tell me about how things are with your dad, it's usually in chambers in the judge's office. It's not usually an open court in front of the parents, because they try not to put the children in that situation.
A question we've got here about a custodial parent wanting to move out of state. What sort of, are there parameters put on that?
Yeah, in every order with children, custody, divorce, any kind of order with children, Alabama has what they call the Relocation Act. It's required to be in every order. The judge won't sign it unless it's in there. And it's usually a couple pages long, and it says in there the requirements if one party is going to move. And you have to give the other parent notice by certified mail. They have certain time limits. They can object to that. If they don't object, then it's presumed that they're allowed to move. But once you're served with a copy of that on the certified mail, you can file something with the court saying, no, I don't agree with that relocation, and the judge will set it for a hearing.
Is that just moving out of state, or is that transferring from county to county? How does that work?
Any kind of move, usually county to county, certainly out of state. But the Relocation Act is very specific. It specifies you have to give them about 10 different things notice, your address, where they're, everything, to let the other party know what's going on. And if you move without doing that, that's really not good. Judges don't like you doing that.
Let's go back to our divorce hat as opposed to the child issues. There are a lot of people in Alabama that claim they're, quote, common law married. They've lived together, filed taxes together, hold themselves out as husband and wife, etc. Let's assume they meet the elements of common law marriage. Do they have an obligation to go through a formal divorce?
They have to.
Okay.
Yeah. I mean, there is no common law divorce. They have to file as if it's a regular marriage, and you have to put that. If the paperwork is a little bit different, that's what I was talking earlier about having an attorney do it, because you have to word it a certain way. Normally in the complaints you have to put the dates you got married, but if your common law, there wasn't a marriage date, so you have to put in there specifically the elements to meet the common law marriage. It's generally hard to meet. I believe the legislature did away with it last year, so it's not even there anymore. But before, it was pretty hard to even get a court to recognize that you were common law married. It's very specific.
Well, what about, have you ever had folks change their mind kind of in the middle of the process or decide?
All the time.
Yeah.
Reconciliation.
Yeah, does that?
It happens.
So it does happen.
It's a good thing.
And you just hit the brakes? How does that work?
Yeah, if they want to put things on hold, they're going to try to get back together. We can file a motion to dismiss the divorce, and the judges always grant it because it's a good thing. Usually, from my experience, they usually end up refiling at some point down the road. That happens a lot. But no, it's good. We encourage that. Sometimes they realize they get involved in it, and it's cost them more than they thought, or they just decide to stay together. And yeah, you can stop it.
Philosophical for a moment. We hear the statistic of 50% of marriages don't last. And a lot of people work very hard at their marriage. What just being in the position you're in, what do you think contributes to that? Is it financial issues? Is it children issues? Is it people grow in different directions? They put up barriers. What's the answer?
It's all of it.
Okay.
Normally, financial struggles is the main thing we see, because that leads to a lot of other issues. If somebody's having financial problems, then they are not checked into their marriage, and they might, all kinds of things can happen. But usually, it's the stress and anxiety from either a big life change, a parent dying or something like that. Children, a child with medical issues that can cause a strain on the marriage. But usually financial issues is the main thing.
I'm assuming there are circumstances where you almost find yourself being a counselor to people before they, because I know, no different than we handle, for example, the personal injury side of things, there are circumstances where, we have to go to them and say, look, we understand this happened, but there's not a claim here at all.
Absolutely.
You don't have a claim. Probably same deal with you where you're kind of counseling people of sometimes, hey, maybe this isn't the best idea. Why don't y'all try and do this?
Sure, and we tell them the good, the bad,
the
most likely scenario, what's going to happen based on your situation in this divorce, even sometimes specifically down to the judge we have. This judge is likely to do this. So yeah, it's a lot of that.
Good experience to have. Hey, we're about to go to break. When we come back, I want to talk about support, because that's something we haven't touched on yet. And child support is an issue that maybe is a little off topic of where we started, but I know that Brad will be able to handle that stuff. And it's an issue that will come up for someone sitting on the couch right now of, hey, my circumstances have changed. How do I change my support order? Those types of things. Let's talk about that when we get back.
All right, right there. We'll step off to take this quick break. As we do so, a reminder, we'd love to have you join our conversation. All the ways you can do so right there. Join the conversation as the Attorneys rolls on.
I'm Tyler Vale with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this. The parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the attorneys. A reminder, this is our final segment, so just a few minutes remaining. Those attorneys from Hollis Wright standing by, but only for a few more moments. So if you'd like to speak with them, again, they're standing by live right now to speak with you, so take advantage of that.
You know, and we don't say enough on this show that when somebody calls, they text, they email, they Facebook us, do it on Twitter, all those options are on the bottom of the screen. You know, there's a live lawyer there tonight to answer calls, questions, whatever they may be. So I hope people will use the service because it is a free service. It doesn't cost you anything to use it. All right, so one topic we haven't covered yet, which falls within kind of the ambit of your role in what you do, is the support guidelines and how that works.
Yep.
Can you give us, if you will, how you'd explain it to a client as a general overview first of kind of how that whole works?
Yeah, child support is calculated based on the income of the parties. We have state guidelines that we use. It's literally a black and white chart, and it tells you what the child support is going to be in almost every case. There's some other factors, that if there's health insurance paid or work-related child care, all that's figured into the equation, but the parties' incomes is the main thing that drives that.
And so what if the parties come to the court, they have an agreement that's inconsistent with the child support guidelines? Do they have the ability to do that and get the court to sign off on it?
They can, yeah, they can do it. You can deviate from it sometimes for certain reasons. If there's going to be, you have to have a good reason, but if there's going to be extra expense for traveling, for example, things like that, as long as the parties agree, the judges will usually go by their agreement.
And then how do, let's say we get this call all the time. I've lost my job, or I've been demoted, or I got a bonus.
Yep.
How does that work insofar as it relates to adjusting the child support requirements per the order that the court signs off on?
Yeah, either party can petition the court to modify the child support. There's got to be a material change in circumstance, which means something major has had to have changed. They can't just change their mind. 10% is usually the standard that the judges will look for, up or down. So if your income goes up by 10%, they'll usually modify it to the increase. If it's gone down 10% or more, they'll usually modify it to the decreased amount.
And do you have a duty if your income went up, say because of a bonus or you got a raise, do you have a duty to notify the court that you've had a material change in your in the amount that you make, or is that up to the other spouse to figure out and notify the court?
It's up to the other spouse.
Okay.
Yeah.
Okay. And then talk to me, I know this has changed over the years, grandparent rights
Yes.
to a child. Is it legal? Can you force it, or is it just within the discretion of the
It
parents?
changes all the time. The law keeps being found constitutional then unconstitutional. About every year it keeps changing. As of right now, it's been found constitutional, so grandparents can petition the court for visitation rights to their grandchildren. They've chipped away at making it easy, so now it's become a whole lot harder. You have to meet higher requirements now, but it is possible.
When can the wife remarry? A question we've got here: how long after this divorce proceeding, can someone remarry?
Yeah, usually 60 days. It'll be in the paperwork, and it'll say if they're going to get back remarried to themselves, which I've never seen happen. But it says in the final order of divorce, it'll have all that in there.
Okay, and just one other thing we had was on changing the name. Any rules as to when like if it's the wife, she can change her name back, or?
Yeah, she can do it at any time. It's a lot easier if you do it during the divorce. You can put that in the complaint, and then when they go to change their name, then all you have to do is take that order, and you don't have to go through the whole probate process of changing your name.
Can you force a divorced parent to change their name back?
No, you can't.
Okay, so that's really a legal-based issue for them. And so, what do you see most? Are you handling divorce cases that work their way into child support and work their way into custody, or is that just kind of all encompassed together?
It's usually
you
all
got
together.
kids, you work them all the way through that process.
Yeah.
So that's not something you want to go alone.
No, definitely not.
Yeah, so you get a lawyer involved, I guess early, and that lawyer can help kind of lead, guide, and direct you through the entire process itself.
Yep.
All right, and then what's typical? Let's say folks get along, they recognize that, that they've got this responsibility of these children over here. Is it consistent to petition the court for changes in circumstance related to child custody guidelines or changes in income, or is it sometimes you're done and that's the last time you see them?
Yeah, that can be the case. I do more modifying existing divorces than filing new divorces. So it's very common, especially in cases with children. The odds are, especially with younger children, something's going to change at some point. Somebody's going to get remarried or move, lose a job. Things are just going to come up. Okay. So we do a lot more of modifying or enforcing the orders if somebody's not following the order. Filing contempt actions, that's very common as well.
If you're in a divorce, whether it's contested or uncontested, is there a rule of thumb you provide to people about when they can start to see another person, date another person? How does that work? Because you know that's a question we'll get tonight.
Yeah, I encourage them to wait until it's final.
Okay.
Not everybody does that, but just to be sure, because until the judge signs off on the final judgment of divorce, you're still legally married. Mm-hmm. And up until that point, anything could change. Somebody could refile something. So even if you're just waiting on the final order, I encourage people to be careful about that.
So that could actually impact your divorce?
It could.
Okay.
Just about out of time, a couple of minutes remaining, but wanted to give both of you an opportunity for a final thought. And Brad, if you will, go first, please.
Yeah, just if you're thinking about filing for divorce, get an attorney. Definitely to help with these kind of matters. The law is very specific. Get an attorney who does this kind of work. Not every attorney, a lot of them think they can do this kind of work, but it's very specific, and you can get in a lot of trouble if you don't have an attorney to begin with, and then if you don't have one who knows what they're doing in this area of the law.
You know, this is, I just close with this. This is a great shining example of a type of the legal sector that our firm never touches on, and we don't know this law. We don't know how to get you through a divorce, and we get you to people like Brad because they know what they're doing, and he's an expert in that area, and he's here to help protect people that go through a divorce and have custody-related issues and have child support, and then also have child support changes and adjustments they need because of income changes and whatnot. This is a relationship that's a long-term relationship, so we would get you to a guy like Brad. I'm so glad he was able to come on the show and answer questions because this is just a great topic that people need to understand what their rights are if they're ever in this circumstance.
Yeah. Brad,
So
appreciate you being here.
Appreciate you being on. Great job, by the way.
Thank you.
Interesting conversation and a lot of ground covered. Appreciate both of you being with us and you as well, as always. Thank you so much for joining us each and every Sunday evening here on The Attorneys. As we wrap things up here, a reminder, just a few minutes remaining if you want to call the attorneys. They're standing by. They're live at that number right there just for a few more minutes. If you want to take advantage of that opportunity. Also, follow the firm. Facebook, just search the term Hollis Wright. Then on Twitter, it's Hollis_Wright. Thanks again for joining us. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.